I'm curious, when did it become unconstitutional to exclude homosexual couples from marriage? 1791, 1868, when the 14th Amendment was adopted, sometime after Baker, where we said it didn't even raise a substantial federal question. When did the law become this?
I may answer this in the form of a rhetorical question. When did it become unconstitutional to prohibit interracial marriages? When did it become unconstitutional to assign children to separate
Easy question,
schools?
I think, for that one. At the time that the Equal Protection Clause was adopted. That's absolutely true. But don't give me a question to my question. When do you think it became unconstitutional? Has it always been unconstitutional?
When the California Supreme Court faced the decision, which it had never faced before, does excluding gay and lesbian citizens who are a class based upon their status as homosexuals, is it constitutional?
That's not when it became unconstitutional. That's when they acted in an unconstitutional matter. Was it always unconstitutional?
It was constitutional when we, as a culture, determined that sexual orientation is a characteristic of individuals that they cannot control.
I see. When did that happen?
There's no specific date in time. This is an evolution.
How am I supposed to know how to decide a case?
Because the case
you
that's
can't give me
before
a
you,
date when the
case that's
Constitution
before
changes.
you today.
Same-sex couples have every other right. It's just about the label.
The label marriage means something. Even our opponents.
Sure. If you tell a child that somebody has to be their friend, I suppose you can force the child to say, "This is my friend," but it changes the definition of what it means to be a friend. And that's, it seems to me, what the supporters of Proposition 8 are saying here. All you're interested in is the label, and you insist on changing the definition of the label.
It is like you were to say you can vote, you can travel, but you may not be a citizen. There are certain labels in this country that are very, very critical. You could have said in the Loving case, you can't get married, but you can have an interracial union. Everyone would know that that was wrong. The marriage has a status, recognition, support, and if you read the
how do we know that that's the reason, or a necessary part of the reason, that we've recognized marriage as a fundamental right?
The problem with the case is that you're really asking, particularly because of the sociological evidence you cite, for us to go into uncharted waters, and you can play with that metaphor. There's a wonderful destination or there's a cliff, whatever the metaphor is.
It was uncharted waters when this court in 1967 in the Loving decision said that prohibitions on interracial marriages, which still existed in 16 states, were unconstitutional.
It was hundreds of years old in the common law countries. This was new to the United States.
And what we have
So that's not accurate.
I respectfully submit that we've learned to understand more about sexual orientation and what it means to individuals. I guess the language that Justice Ginsburg used at the closing of the VMI case is an important thing. It resonates with me. A prime part of the history of our Constitution is the story of the extension of constitutional rights to people once ignored or excluded.
Thank you, counsel.